All right. Hey, I think we are live. We're going to do an audio check as we get started. Good morning, good afternoon, good evening to all you guys all around. Let's double check. Testing audio. Make sure you guys can hear me out there. For those who are joining us today, feel free to go ahead and put where you are, what country you're calling from, or what state in the US if you're in the States, and let us know where you're listening to us from. Um, let's see, audio is good, video is also good. So we're going to start in just a minute. Just want to let everyone know, I know on our announcement we had a slight time difference. Here in the United States, we have what's called this daylight savings, and that time shifts. So it seems that it got shifted to 1 p.m. instead of 12 p.m. Eastern time. So apologize for all of that. For those who are joining, thank you. For those who show up a little later, don't worry, this has been recorded. All the information we're going to talk about today, you can just follow up. If you have questions, everyone, this is your time to interact. We've got a ton of things to cover and go over today. Put those questions in the chat. Let us know what's on your mind, immigration questions, or, things that we don't talk about. Today, we'll be talking a lot about H-1B visas. That's a huge topic or immigration topic that's going on right now, and we want to make sure that we address that appropriately. So before we get started, I also wanted to share with you guys this week, even though we do a lot of employment-based immigration, H-1Bs, E-visas, L visas, green cards, EB-2, 123s, we do need to help out those in need. And right now, everyone should be familiar that the current administration is detaining a record number of individuals, and all of these individuals who are being detained need to go through an immigration process. It's similar to a regular court process, but it is more civil and it is more on the administrative side of things. So there is a process that people need to go through. Very similarly, there's what's called a notice to appear NTA, and the respondents, in this case, not defendants, not plaintiffs, the respondents has to first either admit or deny those allegations that would cause them to be removed from the United States. Once they do that, the court is going to ask for any defenses that they may have. Certain defenses may be cancellation or removal, whether you're come in illegally or whether you're a lawful permanent resident in removal proceedings, or it may be asylum or withholding. So there's a multitude of defenses that you may have. You may be married to a U.S. citizen. So this week, we had one of our clients going through this process, and we had the opportunity to appear by video for one of these hearings. It's a master hearing. There's two main hearings, a master hearing and an individual hearing. The master hearing, think of it as a scheduling hearing or pre-trial, something along those lines, whereas the individual hearing is more evidentiary. Think of that as a trial, but in a civil context. Anyways, so what I noticed, and this is just sort of speaking personally, I logged on a little bit early, and the court was going through the detained document for those individuals who didn't have an attorney. There is an extraordinary number of people who are not represented by an attorney, and specifically a really good immigration attorney. Many, there were at least 20 to 25 ladies in this case, because I guess they were just doing the women's at this time, 20 to 25 ladies, all who did not have an attorney. A few of those individuals said they had attorneys, but their attorneys didn't show up by video. I don't get it. I mean, if you're going to pay all this money, your attorney needs to show up, or at least let the court know that they're not going to show up and why they can't show up. Unfortunately, what we have found is there's some attorneys who really just don't provide really good service for their clients. And that was on display through this process. Out of the 2025, many didn't know what was going on. Some tried to represent themselves and they just didn't know what to do. The court can't give them advice and help. It really was a very emotional, sad, and desperate moment as I kind of watched the judge go through each and every one of them. Pretty much all of them were Spanish speakers and from various countries from Venezuela, Ecuador, um, El Salvador, Mexico, all over, and they just didn't have representation. So I want to encourage people. We'll talk about that at the end, but we do represent several people in removal proceedings. There's not enough immigration attorneys out here. Please reach out to us. There's going to be a number on the screen, or you can call us at 888-401 1016, or the number that's on the screen. Also, we do have people who do speak Spanish. You really want to have an immigration attorney that's going to show up, communicate with you, and represent you the best that they can. It's not an easy process, no matter which defense you're seeking. And the government continues to put up challenges for those seeking asylum in the United States. We'll talk about one a little later. All right, but anyways, unfortunately, in our case, we had to change jurisdiction. For whatever reason, the system, and shows you how unorganized the system is. The current system had our client under a judge that has no jurisdiction over her. So the judge said, I have no jurisdiction. We're going to have to change venue to a new jurisdiction. So once we change, we're going to do the bond hearing and get her out of detention so she can get back to her family who is waiting for her desperately. So we do this all the time. We're here to help people. We're here to help you. If you have questions, please drop those in the chat and comment below. So what I want to do before we get into our main topic today as we talk about the H-1B $100,000 fee, I want to go over some of the most recent topics going on and give you an update. One of them kind of impacts us, or I wouldn't say impacts us, but is something dear to our heart that we want to touch on, okay? For those who are joining, again, my name is Anthony Ray. I'm one of the attorneys here on the Ray Law International channel and our firm, Ray Law International. We help our clients navigate the chaotic immigration process to bring success to you, your company, and to your family. So give us a call at the number attached. All right. Oh, sorry. On the number on the screen. All right, guys, let's dive in. So we're going to start off with the 10 top immigration updates that I want to make sure that you guys are aware of to make sure that you know what's going on. There's a lot of news on the on this social media and all out there, but let's focus in on what's really important. So first and foremost, the Supreme Court has agreed to review the legality of asylum metering. That's a policy that limits how many people can apply for asylum at the ports of entry. This case will determine how much power the government has to restrict asylum access. As you know, this current administration is just trying to do away with asylum altogether. There are lawsuits challenging that, of course, and now the Supreme Court is looking at asylum metering. Pay attention to that as it moves through the court system. Second, we're seeing a renewed controversy over family separation practices, as reports indicate that these tactics are being used against, again, as part of a broader mass deportation efforts. So before, the government was trying to bring them together, families together. Now we're seeing that families are being separated. Prime example, the example I gave you before, I have a client who has a 5-year-old at home. They were already in immigration removal proceedings. There was no reason to put her into detention. However, they just detained her, picked her up, detained her, even though she's already in the process, even though she has an asylum application pending. No reason. She's not a flight risk. She's not a danger to the community. And our government is wasting resources and time focused on just throwing anybody and anyone they can into detention. The next or third one is DHS, Department of Homeland Security, officially ended the 540-day automatic extension of work permits. Many immigrant workers will now face gaps in their employment authorization unless renewals are filed and processed early. This is a very hot topic. There's no reason they should have withdrawn this. There's no fraud. People are just want to work. And the government's process of EADs in some categories, it's taking seven months. We generally speaking, under immigration, we can extend applications 6 months prior to expiration. There are some attorneys, because of this impact in the long processing times, they are trying to file earlier, and some have been successful. That's not a practice we have implemented at our firm yet. However, it may be something we need to consider when processing times are taking longer than 6 months for the government to process extensions or renewals of employment authorization documents or these work permits. Again, if you have questions about this or any others, put them in the chat. Number 4, the federal courts has halted the newly imposed $100 asylum annual fee, forcing the USCIS to pause implementation. Now, if you're not familiar with this, the USCIS implemented a $100 fee for an annual fee. So every year we've got to pay $100 if you have an asylum application pending with the USCIS. Whether you have an affirmative asylum application, meaning you're outside of immigration court, or whether it's a defensive asylum application, meaning you're in immigration court. Either way, you got to pay this $100. If you can imagine that there's a million asylum applications pending with our government, you just times that by 100 and you can kind of get an idea of what the government is raking in annually. What they're doing with this money, we don't know. The government has not made that clear. Obviously, if our federal government has funded, Department of Homeland Security billions of dollars, why do they need to charge additional fees? The government has sufficient fees to enforce and process these asylum applications. In addition, not only is there this $100 annual fee, for those who do not know, U.S. employers also have to pay a $300 or $600 fee on each petition or application that they file. So the government is really double dipping. They're getting money from left and right for asylum applications. And is this helping to pay for anything? We don't know. There's not enough transparency or clarity for this, but the government is getting more money from asylum applicants. Number 5, major changes are underway for businesses. DHS is advancing a weighted H-1B selection rule favoring higher paid roles, and the Department of Labor has launched Project Firewall to enforce hiring protections for U.S. workers. Look for that coming very soon. We're already talking about H-1B registration in March. A lot of clients are looking to hire these young people out of college or the people that they need that they cannot find here in the United States. Number 6, DHS announced termination of TPS, or temporary protected status, for Syrians, giving individuals a short window to depart unless they qualify for another status. If you are on TPS and you are from Syria, figure out what you need to do, act quickly, give us a call to see if you qualify for some other category. Unfortunately, the government is going through in 2025 and will continue in 2026 to eliminate TPS for most, if not all, of those countries who really, really do need it. There's really no reason to terminate it, but they are. So take action. You cannot afford to wait. Next, 7th, ICE is undergoing a massive hiring surge, aiming to add over 10,000 new officers, but the rapid expansion is facing scrutiny and for inadequate training and preparedness. You see this on the news every single day about ICE and the implementation and hiring practices. We'll watch the courts to see where this is going and how it progresses, but they are hiring people. So for all those hundreds and thousands of people who got laid off, unfortunately, you might need to look to the federal government in order for work. Next, eighth, the Attorney General body has issued decisions that narrow asylum eligibility, mainly for individuals fleeing domestic violence or gang-related harm. This just means, again, as I mentioned at the top of our discussion, it's going to be harder and harder to meet the requirements for asylum. You can file, but that bar to get approved is going higher. This is why you need an attorney. Just because you feel your facts are good or you were a victim or persecuted doesn't mean you're going to be able to navigate the procedures in order for a successful case in asylum. Get in an attorney, get in a good attorney you trust that can take you through the process. Number 9, the government has expanded enforcement operations under Operation Safeguard, increasing raids and courthouse arrests as part of its removal strategy. Remember, I talked at the top where there are thousands and thousands of people in detention that need immigration representation. Can they afford us attorneys? Some can, some can't, but they desperately need representation. And I would, even though I don't have the evidence to back this up, I would say a lot of nonprofits are hard pressed to represent the thousands and thousands of people who are in custody. Give us a call if you or someone you know needs representation in immigration court. We can appear by video, whether you're in California, Miami, Texas, or in New York area. Reach out to us if you're looking for a trusted immigration attorney. And 10th, before we jump to our main topic for today, is DHS has implemented a new $1,000 parole fee, raising the cost of humanitarian and other parole programs in a significant way. It seems a little odd that we're tacking on fees for humanitarian purposes where these people are trying to help others or there's a problem in their country. Why are we charging an additional $1,000 fee for parole fees? I don't know, but there is a fee. Now, this does not apply to all. Well, it does apply to all, but there are exceptions. So you need to contact an immigration attorney to see if you have advanced parole and whether you fit within those exceptions, or more importantly, if you know you fit within those exceptions, how to communicate that effectively to CBP to make sure that you're not paying needlessly $1,000 out of your account to the government to, for whatever reason, our government's using these $1,000 fees. So together, these developments reflect the most aggressive overhaul of immigration policy ever seen in years, affecting families, employers, humanitarian programs, and especially the courts. One last thing before we jump into our topic today. It was very interesting. I was talking about our experience in immigration court. The judge was flummoxed and overwhelmed by the number of cases he had on his docket. And then, he's got 25 detained not represented by attorneys. And then he's got another 20 who are represented by attorneys. And that's a heavy caseload. And we have to remember a lot of these immigration judges are under pressure, one, to properly adjudicate and go through the process, but also they're probably getting pressured from the AG and the government to move these cases forward. So, you can put 1 million people in detention, but if they got to go through the court process, it's just going to take that much more time. So remember your immigration judges. We hope that those judges will do the right thing. The one on our case, he was spectacular. He was looking out for the interests of the government and also the interests of the individual, and strongly encouraged individuals to show up with an immigration attorney. It's going to make his life a lot easier, and they're going to make sure that they're represented properly. All right, folks, any questions? Remember, if you have any questions, yay, we got watching from the Philippines. Thank you, Sahara. And in addition, if you guys have questions, go ahead, drop them in the chat. We would love to answer your questions. It may be on our topic regarding the H-1B, $100,000 fee, or any others. We're here to help. So feel free to just let us know and drop that in our chat, whether you're listening to us through YouTube, LinkedIn, or Facebook, wherever you may be reaching out to us from. Reach out to us. Let us know what country you're calling from or what state. All right, let's jump into our topic for today. In September 2025, a new presidential proclamation suddenly imposed a $100,000 fee on each H-1B visa petition. This move triggered two lawsuits, which we're going to talk about today. The first, Global Nurse Force versus Trump, which is from a healthcare staffing firms and others who argue it exceeds the presidential authority, threatens healthcare workforce, and disrupts the immigration system Congress established. I'll summarize the three main points for this case of their complaint and explain why this policy raises serious concerns. First, and make sure we have that up, Jen. Go ahead and share that screen. We have a slide presentation. Oh, one other thing I wanted to mention before we jump in, and I already started. Whoops, Jen, go to the criminal defense. Our firm, as you can imagine, with a lot of the layoffs and criminal matters, our firm also does criminal defense locally out of our Michigan office. So just check out our Ray Law Criminal Defense YouTube channel. It's great. Reach out to us. Misdemeanors, or if you need quality and good criminal defense, we're here to help. We've been doing this for many years. Check out our videos on numerous topics, everything from misdemeanors to felonies to murder. It's on there. Okay. Thank you, Jen. Let's jump back to our presentation. We got a slide presentation. Let's focus on that and put me aside. Excellent. All right. So that is the first. We're going to hit 3 points on this lawsuit, the first of the two. First, the plaintiffs argued that the September 2025 presidential proclamation, along with the agency policy implementing it, suddenly imposed a $100,000 fee for every new H-1B petition and related visa or entry. They contend that this fee exceeds the presidential authority and constitutional authority. The second in the complaint, the plaintiffs warned that this fee structure will cause immediate and serious harm to the U.S. healthcare systems and staffing firms like Global Nurse Force by making it financially unfeasible to hire international nurses through the H-1B visa. The policy could worsen existing nurse shortages and drive up costs and ultimately threaten patient care. For those who don't know, we have a nursing shortage and we need more people. This just goes against that. It doesn't make any sense, but let's go to the next. Finally, the complaint asserts that this fee requirement disrupts the carefully crafted immigration system that Congress established for H-1B specialty workers, including foreign-trained physicians and academics. The executive branch, they argue, cannot unilaterally override or supplement this system without proper legislative authorization. This is just basically saying the government doesn't have the authority to do this. And you'll see this also when we talk about the second case. Also, the executive branch is doing what Congress should be doing. So, the current administration really needs to follow the laws and everything that has been set up. Congress already has a system for H-1B. This is disrupting it and changing that dramatically. Now, let's turn our attention to the second lawsuit. The second lawsuit is the U.S. Chamber of Commerce v. Department of Homeland Security. Let's discuss the key issues raised in the complaint challenging the recent presidential proclamation on H-1B visas. Let me walk you through 5 of those points. First, the complaint argues also that the $100,000 fee per new H-1B petition exceeds the limit set by law. Under the INA, or the Immigration Nationality Act, fees must reflect the government's actual cost of processing the visas, and they are not meant to, or they cannot be used to serve as punitive or regulatory penalties. This proclamation, the complaint contends, goes well beyond the legal framework. Okay? It doesn't cost them $100,000 per application. And if you want to get an idea of what this looks like, just take $100,000 and times it by the 85,000 H-1B visas issued each year, and you can start to see how much money our government is raking in through this fee. Okay. Second, the executive branch, according to the complaint, cannot unilaterally rewrite the rules of the H-1B program. By imposing this fee, the proclamation attempts to override the statutory structure established by Congress. It effectively restricts entry of certain specialty occupation workers unless employers pay this exorbitant fee, a clear example of executive overreach. And one thing I wanted to highlight, our firm has used H-1Bs in the past, and absolutely there's no way we're going to pay or would be in the position to pay an additional $100,000 to the government in order to utilize this. And unfortunately, when it comes to bilingual attorneys, there's just not enough US bilingual immigration attorneys, or in many cases, paralegals, which we don't use H-1Bs for paralegals as much, but especially for immigration attorneys, there's not enough of them out there. So sometimes using the H-1B categories for attorneys is ideal and necessary. Third, the complaint highlights that the proclamation bypassed the Administrative Procedures Act's requirements, or the APA you'll hear in the news often. There was no proper notice, no opportunity for the public to comment, and no reasoned explanation. By skipping these essential procedural steps, the actions is deemed arbitrary and capricious. Those are key terms of art that are needed in order for the plaintiffs to be successful. I don't know why, from my standpoint, why the administration, if they're going to do this, just doesn't follow the process. I mean, if they really wanted to do this, they give public notice, they give the opportunity for the public to respond, and they give a reasonable explanation of why they need to charge $100,000 for each application for these individuals to come in. Next, number 4, imposing a $100,000 fee will place a severe burden on U.S. companies, particularly smaller and growth-oriented firms that rely on H-1B talent. The complaint emphasizes that this threatens innovation, investment, and the overall competitiveness of key sectors in the U.S. economy. Finally, the proclamation provides no adequate findings showing that the entry of H-1B workers as a group harms U.S. interests. Under the statute, now, a lot of people argue that H-1Bs are taking U.S. jobs, but the government has not provided any evidence that this is the case. And when you see the need out there, it really is misplaced. I often encourage people, even U.S. citizens, all U.S. citizens should be in the STEM field, okay? Forget the social science. That's where we need people. Everyone needs to be an engineer. This whole idea of, in the American way, just do what you want or do what you like, doesn't work for the employment workforce. Everyone needs to be getting into AI fields and changing and evolving. Whether you like it or not, whether you feel you need or not, that's what the industry needs. So instead of getting engineers and IT professionals from outside the U.S., we need to be funneling all of our U.S. citizen children, or forcing them to go into these fields to meet the demand of the companies. Now, finally, the proclamation provides no adequate finding showing that the entry of H-1B workers is a harm to U.S. interests. Under the statute, restrictions can only be imposed where there is a specific threat of clear national interest justification. The government hasn't done this. The complaint asserts that the administration fails to meet this legal standard. Now, these 5 points form the backbone of the legal challenge that the fee exceeds statutory limits, represents executive overreach, violates procedural rules, harms U.S. businesses, and lacks any factual basis. Each of these issues highlights why this proclamation is being contested in court. Now, let me double check. Now is the time for you, employers and advocates to stay engaged, speak out, and ensure that lawful, fair, and economically sound immigration policy prevails. Call us today for guidance in navigating this chaotic immigration environment. Let me see. And before we finish, are there questions out there? If you have questions and you're listening to this afterwards, feel free to touch base. Put your questions in the comments. We'll respond later. Or you can email us. I'm going to have our staff put that contact information on our screen. Go ahead. If you can go to that last slide there. And show that's going to have our contact information. Reach out to us. There is so much going on weekly, daily in the immigration scene. The two cases that we just talked about, they're still pending. These are the legal challenges. Will these cases receive an injunction or procedures to stop the government from implementing this 100,000 fee before the next H-1B lottery coming up? We don't know, but you got to stay tuned. You got to pay attention to what the courts are doing. They should move quickly because this is drastically going to impact all the employers' decisions of whether they're going to hire foreign nationals in the upcoming H-1B lottery in March, or in registration lottery in March. All right, guys, I want to thank you for joining us today. Again, reach out to us with questions. We're here for you. We'll be here next month at the end of the month. We'll let you know. Until next time, stay educated, stay informed, and stay on the right immigration path. See you. Thank you for joining us. Bye now.